Okay, so hello everybody and welcome to the first of our two expert-led webinars. These expert-led webinars have been co-organised by Seratium for the Capitalised project with Euroseeds, and we've aimed these at selected Horizon European projects that Seratium and Euroseeds are both involved in. So this is what these discussions today are about. So we've got, as I said, we've got two speakers today. We have Szonja Csörgö, and she's joined by Mrs. Tony van der Boom. They're from the International Seed Federation and from BASF and Anonymous. So I'm going to hand over to Nick from Euroseeds.
I am now going to presentation mode and quickly walk you through some of the considerations from Euroseeds. So for us, we ask the question, it's really important, how can we help to facilitate research uptake by the seed and plant breeding sector in Europe? And so in Euroseeds, we are a business association representing companies active in Europe, but also more abroad. And in the context of this webinar series, I wish to highlight that, if you are interested in research in a particular crop, your R&D budget and your strategy of a business, or let's say to develop a variety to the market, it depends on of course, the crop specificities and the research limitations and opportunities, but also the market size of your crop, the regulatory frameworks that apply, and so the technology readiness. And so when we actually engage with public actors active in the field of plant research and breeding, I wish to highlight that if you actually are going to develop a new plant variety, besides the great research that you're doing, you need to consider many other different aspects. Where is your genetic resource coming from? Does it hold any intellectual property protection, or do you wish to aim for that also with the final product? What about phytosanitary aspects? So there are many different aspects that need to be taken on from the beginning of the R&D process in order, if it's your wish and your goal, to end up with a new plant variety to the market as depicted here. So we think there is an essential and important aspect of collaboration between public actors and also businesses in the research and breeding in space of the road towards a plant variety to the market, where then usually more really the businesses are more experienced in. So we're very grateful to have received this request, and it's my pleasure to give you a small introduction on the two speakers of today. So first of all, we have Szonja Csörgö. She holds a degree in law, and actually she gained experience at different universities. So first in Budapest, then in Paris, and then in Liège. So also addressing European law, competition law, and that's also usually a question what I get, like if you work in the end on specific expertise like Szonja is now doing at the International Seed Federation as an IP and legal affairs manager, when she started before her career at Euroseeds, where she worked almost for 15 years. I don't know how familiar you were with SNPs or molecular markers and so on, but so usually you come from a legal background, an economic background, or a scientific background, and along the way you gain the experience in a specific sector. So Szonja holds really this unique and elaborate experience in intellectual property and legal matters, and also, of course, the plant breeding related aspects. So I'm happy to give the floor to you, Szonja.
Thank you, Nick, for the introduction, and good afternoon to everybody. The topic of today's webinar is how does the Nagoya Protocol and other access and benefit sharing regulations affect the use of your research as public research organizations or academia. from different points of view. So what I would like to do in the first part, more look at the international framework for access and benefit sharing of genetic resources, and then have a look more at the European aspect, how the EU regulation on access and benefit sharing actually influences what you can do in projects, collaborative frameworks, and what needs to be paid attention to, what kind of obligations there are. So first on the international aspects, and back to the concept that we are talking about, ABS, access and benefit sharing. Okay, we know that this is the abbreviation, or this is what the abbreviation stands for, but what does it mean actually in practice? Because you can ask a lot of questions in the different letters of it. Okay, access, but access to what? By whom? From where? For what purpose? All these questions you might ask yourself. Same for the benefit and the sharing. What kind of benefit are we talking about? From what? By whom? And sharing with whom? Sharing benefits from what? And why? And by whom? So all these questions might come to your mind when you dwell deeper into the concept of access and benefit sharing. But it's important to know that the answers you can find if you look at the different backgrounds to the whole access and benefit sharing discussion. Of course, it's a legal framework at the international level, so you have to try to find your answers to these questions from a legal perspective, look into the regulations and what is in the regulations. But it's also a political concept and a technical one. So you have to combine all these aspects, the technical aspects to genetic resources, the legal framework, and the political discussion, the political concept of ABS, which is trying to bring back the balance between global south and global north. And that's when you can start understanding how the whole access and benefit sharing framework and the obligations and the rights which are covered in there come together and how they work. So trying to put it simpler, who are the actors in access and benefit sharing in general? So this is like a simplified scheme, let's say, of who we should have in mind when we talk about access and benefit sharing relationships. So we have the provider country, the user, and the beneficiaries, let's say. The beneficiaries can be the provider countries as well, of course, but there can be more direct beneficiaries of benefit sharing, such as indigenous peoples or local communities. Now, of course, the provider country is the one who sets the regulatory framework for access and benefit sharing. And then the first relationship will be between the user and the provider country. So the provider country provides the genetic resource to the user, and the user has certain obligations and rights, of course, because once the contract, it's a contractual relationship which will be put in place between the provider country and the user. There are rights and obligations for the user, and also the obligations on how to share benefits will be set out in this contractual relationship. There can be a relationship if there are direct beneficiaries established in the regulatory framework of a provider country. There can be rights established by national laws for recognized communities, communities like local communities who are recognized in national laws, or indigenous peoples who are recognized. Not in all countries these groups of people are recognized, but in many, especially mega diverse countries, they are. So there is this legal relationship, so to say, that some rights are established, and then the provider country may have to share benefits with local communities from what they collect from the users. And of course, the beneficiaries, the indigenous peoples and local communities, they conserve genetic resources. And there can be also a direct relationship between user and direct beneficiaries, because there might be an obligation in the contractual relationship between the provider and the user to actually share directly benefits with the indigenous peoples and local communities. And they also might have some rights to authorize use of genetic resources which are conserved by them. So it can be that the national law actually obliges the user to also ask for permission from certain communities to have access and to be able to use genetic resources. And further on, the user might have an obligation to pass on these obligations to user number 2, 3, 4, 5, and so on. And that will also be a contractual relationship. But how is actually ABS organized at the international level? You might have heard about the different international treaties which exist. So those are the modalities of organizing ABS at the international level. It can be bilateral or it can be what we call multilateral. Well, what does it mean in practice? I will come back to that in the next slide. So when we talk about the bilateral way of organizing access and benefit sharing, we actually talk about a situation where the user will have to have bilateral negotiations each and every time with the provider country on access and benefit sharing. Compared to that, the multilateral way of organizing access and benefit sharing is a system where basically countries renounce from their sovereign rights on genetic resources and they accept to put them into a multilateral basket, so to say, from which users can actually access in a easier manner. But we will come back to that. And then there are several layers to the organization because we have the treaties at the international level, but those are then implemented at several stages. Because an international treaty normally does not generate rights and obligations, they have to be implemented in the own legal system of the contracting parties to actually generate rights and obligations for users and for other people who are implicated by the legislation. So normally that's the national law which will translate it into obligations, but there can be a level between international and national, which is normally the regional level. And in the case of the EU, we have this regional layer with the EU legislation, which will come back at the end. But there can also be local levels. So under the national, there are countries which are like federal states. So they have more locally organized ABS legislations as well, which is not a unique situation. So it can even further complicate the life of users of genetic resources. So this I will not go in details. It's just to give you an idea of the fact that we have these at least two big international treaties, the Convention on Biological Diversity and the International Treaty on Plant Genetic Resources for Food and Agriculture, which are developing in parallel to each other. And I will also explain what is the difference and the relationship between the two. But of course, the CBD was the one which came in first in the beginning of the 1990s, and then the international treaty came more in the beginning of the 2000s, but they coexist parallel to each other, and there are lots of discussions going on still in both fora. So on implementation and further development of these international ABS frameworks. Now, for whatever reason, yeah, now it's moving. So first, let's go to the CBD and the Nagoya Protocol. So the CBD, the Convention on Biological Diversity, adopted in 1992, is a general framework, a general international treaty on genetic resources. And it has a number of protocols, not only the Nagoya Protocol, it has other protocols, but the Nagoya Protocol is the one which implements the access and benefit sharing concept that has been laid down already in the CBD. And the Nagoya Protocol came into existence in 2010 and it entered into force in 2014. So it's the two together which will actually determine how the ABS frameworks look like. And those both are implemented or both can be implemented in national ABS laws by the contracting parties. So nowadays the CBD has close to 200 contracting parties. The Nagoya Protocol has 141, already many. So this picture basically shows the parties to the Nagoya Protocol. But there are still some who might have signed it but not ratified yet. So implementation is still ongoing. Now, what are the key features of this CBD/Nagoya Protocol way of accessing genetic resources? So as I said, the scope of these is covering all genetic resources except for human genetic resources. So not only plants, but also animals, marine genetic resources, and so on. And it applies to all the genetic resources that are under the sovereignty of the contracting parties, which are accessed after the entry into force of those treaties in the given contracting parties. This is the bilateral way of dealing with ABS. So it means that if you want to access a genetic resource which falls under the scope of the CBD or the Nagoya Protocol, you need to start bilateral negotiation with the provider country. And usually what you need to negotiate is prior informed consent, the famous PIC, which is the authorization from the country for you to use the genetic resources, and MAT, the mutually agreed terms, which will be the terms and conditions under which you can use the genetic resources and have to share benefits. So both the access and the benefit sharing is basically bilaterally negotiated between the provider and the user. The Nagoya Protocol also contains compliance measures. So it foresees that user compliance needs to be checked. So the contracting parties to the Nagoya Protocol have the obligation to put in place user compliance measures in order to make sure that users have accessed genetic resources and use them in compliance with applicable ABS legislation. Another important element to mention is that the CBD and the Nagoya Protocol basically generate cumulative obligations. So each and every genetic resource that you access will have its own obligations coming with it, because you might combine in a variety a genetic resource from Peru and another one from South Africa. And for those, you will have separate contracts negotiated. So all those obligations will be combined in your new variety because you have used both genetic resource. And it depends on the contractual terms whether you need to pass on your ABS obligations for the further uses of your new plant variety. Now, the multilateral way of dealing with the ABS is what the International Treaty on Plant Genetic Resources has put in place. The international treaty is also a framework, but it's only for plant genetic resources for food and agriculture. And whereas the treaty itself, it's about conservation and sustainable use of plant genetic resources as well as ABS, it has a separate part which talks about more the ABS related matters, which we call the multilateral system. So one part of the treaty, Articles 12 and 13, basically talk about the creation of this multilateral system of access and benefit sharing, which describes the way how contracting parties decide to renounce from their sovereign rights and put their genetic resources, which are in the public domain and under their management, into this multilateral system from which users can access those genetic resources and use under certain terms. And those terms are basically laid down in something that we call the Standard Material Transfer Agreement, or in short SMTA, which is a standard contract. You don't have to negotiate each and every time. The terms are known, so it's much easier. The treaty has a bit more contracting parties than the Nagoya Protocol, 152 now, with Colombia joining as the latest member. So coverage is improving, but you can see on the map that there are still significant parts of the world which are not part to the international treaty. So as I mentioned, the scope is more limited than the CBD and the Nagoya Protocol. It's only for plant genetic resources for food and agriculture. And the ABS system actually only applies, so the multilateral system of ABS, for those crops which are on the famous Annex 1 of the treaty. So it's only 64 species that benefit from this multilateral system of access and benefit sharing. So those species that are not listed on this Annex 1, for example, tomato or soybean, they are not listed on Annex 1. So even if the country is a contracting party to the international treaty, since soybean is not on Annex 1, soybean genetic resources will still have to be accessed under the CBD and or Nagoya Protocol conditions if the country is also a party to the CBD and or the Nagoya Protocol. Important that access is under the standard conditions of the SMTA, but only for the purposes which are laid down in the SMTA and the treaty, so only for research, breeding and training for food and feed purposes. So it's not possible, for instance, to access maize genetic resources under the SMTA for industrial use, because the treaty says that it's only for food and feed purposes that you can access under the SMTA conditions. If you want to access for another use, you need to again go through the Nagoya Protocol CBD system. So you can start realizing that it's getting more and more complicated as you dwell more and more into it. Also, the benefit sharing terms are laid down in the SMTA. Currently, it's based on commercialization. So once you commercialize a new variety, which includes material from the MLS, you might have a monetary benefit sharing obligation, but not in all cases will it be the case. Compliance checks are not foreseen in the treaty. Positive thing is that the obligations are not cumulative, so you only have one benefit sharing obligation on a new plant variety that you might put on the market, regardless of the fact how many genetic resources you have used in the creation of that variety from the multilateral system. And it's also important to mention that the SMTA basically does not oblige you to pass on obligations once you have a commercial product on the market. So that is basically the cutoff point, the benefit sharing obligations. If you pass on material which is not yet commercial, but you make a breeding agreement between two breeders, then you have to pass on your ABS obligations under the SMTA, but not when you go to market. So what does this complexity mean for a user? Well, a lot of trouble, I would say. So you need to understand which frameworks applies to which crop, to which country, to which use. You have to be able to find out where you can find those laws, and you have to be able to try to understand what those laws actually say and what kind of obligations you might have. If you fall under the bilateral system, then you have to negotiate ABS contracts. Once you have negotiated your contracts, you need to have good databases in place to be able to document and follow what happens with the genetic resource to make sure that you are actually compliant. You also need to follow up on your benefit sharing obligations, and maybe you also need to pass it on to others. And of course, you might need to deal with authorities if compliance checks are coming, and be collaborative in trying to make sure that you facilitate the work of those authorities which are responsible for the compliance check. So in practice, actually, I have to say that the ABS legislation might not reach the goals for which it has been set up, because many users, whether they are public research institutes, academic institutes, or commercial users, might not have the means actually and the capacity to deal with this complexity of legislation, because it requires a lot of time, a very good understanding, and sometimes expertise or language knowledge, let alone, that you might not have, because if you might want to access something in Brazil, you might need to go through actually a specialist or a law firm which is based in the country who can help you getting through all the legislative and administrative complications. And not everybody has the time and the money to invest in that. So what will happen in practice is going to be avoidance. Companies and other users will just conclude that, okay, I don't have the capacity to go through all this hassle, so I'd rather go for another source or another resource that I might be able to access easier and use in my breeding program. Nevertheless, it's also important to mention that there are some information sources which are meant to help your compliance, but unfortunately, it's not always complete or not always reaching the goal that you want to reach. But I think Tony will explain that more in practice, how these lack of information impacts your use in the end. And there are also some industry sources. For instance, Euroseeds has created important resource database, so that's also available for breeders to use. Now, before I go to the EU regulation, I just wanted to also spend maybe one slide on DSI, digital sequence information, because of course, we mostly wanted to talk about genetic resources, but nowadays a lot of discussion has been going on digital sequence information. So I think it's worthwhile. And also I understand that many of the projects that you are involved in not necessarily only work on genetic resources, but also information generated from genetic resources. So it might be relevant to understand where we are on this discussion. So what is digital sequence information? Well, I think some of you might know this graph. It comes from the CBD, which basically shows the different extend how you can understand digital sequence information. But we still don't know what we mean by digital sequence information, even though today there is a system which has been established with modalities. It's still not clarified what is the extent of digital sequence information to which it applies. Why do we talk about digital sequence information? I think the most straightforward answer is that because it's a political idea which came up, that it would be important to expand ABS legislation also to the use of information derived from genetic resources in order to avoid that legislation applicable to physical genetic resources is bypassed when some industries use only information, and with the hope that maybe more monetary benefit sharing might come into the CBD system if ABS also applies to information. But why is it important for us to talk about DSI? Because, of course, it's used also in plant breeding in different activities, and I've just put some typical ones here on the slide, which just came to my mind quickly. So, of course, marker-assisted selection, genome editing, screening, large-scale screening of varieties for looking for some characteristics, characterization of genetic resources, which might mostly done either in collaboration between gene banks and companies or by gene banks. So not only for commercial use, but also for conservation, the use of digital sequence information is important. Where are we now with this discussion? Well, a few weeks ago, there was a decision from the last Conference of the Parties of the CBD on DSI. So the positive thing maybe is that access to DSI still remains open. So the international framework which has been put in place only applies to benefit sharing, not to access. But there is now a multilateral mechanism of benefit sharing on the use of DSI that has been set up by the CBD together with some modalities which have been now put into a decision. It appears that this system will only apply to public DSI. So DSI, which is in public databases. All users in some determined sectors who make direct or indirect benefits in their commercial use from the use of DSI, they will have to pay in one or the other way. Plant breeding is one of the sectors that is listed in the decision. And as an indicative rate, it's 1% of the revenue or 0.1% of profit that will have to be paid into a global fund. Users not having a commercial benefit from the use of DSI do not have a financial or monetary obligation, but everybody has some benefit sharing obligations according to the decision. So for instance, public research will very likely not have any monetary payment obligation unless there are commercial benefits made. But a big question is, how will this affect partnerships, of course, between public and private as we go along in the further implementation of the system. So it's now the CBD COP decision which is in place. How this will be translated into practical obligations, that is still to be seen, and it's too early to say anything about that. Now, going to the EU ABS regulation, which is more concretely impacting our activities also in EU projects. So where does this EU regulation come from? It comes from Article 15 of the Nagoya Protocol, which is the article that has created basically the compliance pillar of the Nagoya Protocol, saying that compliance with domestic legislation on access and benefit sharing has to be checked by contracting parties. So the contracting parties have this obligation deriving from the Nagoya Protocol to put compliance measures in place. So the EU has done that through EU Regulation 511 of 2014, which entered into force in 2014, some parts a year later. So this regulation is basically on compliance measures, only on compliance measures, not on access and not on benefit sharing. So it impacts users of genetic resources because the members of the EU, the member states of the EU are in an obligation to actually check user compliance in certain checkpoints, but I'll come to that. So the main elements of this EU regulation is basically that it applies to genetic resources which are under the sovereign rights of contracting parties to the Nagoya Protocol, and also to associated traditional knowledge, which has been accessed after the entry into force of the Nagoya Protocol for the EU. That means October 2014. So everything which has been accessed after this date will fall under the scope of the EU ABS regulation. Of course, there are some other conditions on the applicability of the regulation, but those we can discuss later if there are any questions on that. So what are the obligations which are established by this regulation is basically a self-assessment system, which is called a due diligence obligation within the regulation. So users have this obligation to be diligent in their access and benefit sharing obligations, contractual or regulatory obligations. So make sure that they comply with applicable ABS measures where there are ABS measures applying. They also have an obligation according to the regulation to do a declaration, a due diligence declaration, at certain points in the development chain, and that is laid out in the regulation who and at what point has to make a due diligence declaration, which is a self-declaration, again, about having accessed the genetic resources that are used in a compliant manner, having accessed and used. The regulation also foresees some deterring sanctions, which have to be put in place by the member states. And it also provides for monitoring and compliance of, monitoring of user compliance and compliance checks, which have to be, again, put in place by the member states. So why ABS is a tricky issue in practice? Well, I think you probably have already a very good idea about that. One thing is that, of course, there are international frameworks and national frameworks, but those are usually translated into contractual obligations. So you need to basically be very active in your access and benefit sharing and compliance when you are a user of genetic resources or traditional knowledge. Awareness is, of course, key, but it's not always obvious. So we should all be aware of our ABS obligations, but it's not so easy to be aware. Even if I want to be aware, it's not obvious how I get the information, where I find the information, how can I understand what are my obligations and what are my rights eventually. So already finding out and trying to be aware is a challenge for all the users. Compliance is a must, of course, because we all want to be and have to be compliant, but it's complicated because sometimes you cannot be sure whether you are compliant with the legislation. So the solution will be avoidance, or meaning not using genetic resources where you cannot be sure of your compliance, which has a negative effect on the use of genetic resources in general. So how does it look like under the EU ABS regulation? Yet again, you need to know what comes in. So what are you accessing? And whether you have accessed them in a compliant manner. You need to track the use of your genetic resource all along, and you also need to know what goes out, and if there are obligations, either to make a declaration or to pass on obligations to subsequent users. Of course, you also need to be prepared for compliance checks and be ready also to cooperate or collaborate with authorities. So why is it important for academia, public research to know about this obligation or the existence of the EU regulation and what is in there? Because all users need to comply according to the regulation. Although in some cases, the obligations are different for public research or non-commercial research in particular. So different conditions may apply then to commercial research. But that has the implication, of course, that sometimes the transfer of research results between non-commercial and commercial users might be complicated because some national laws have different access and use conditions for non-commercial and commercial use, which means that in some case, if you want to use the research results in commercial use afterwards, the commercial user might need to go back to the provider country and renegotiate terms, which is relatively complicated. But of course, in any case, compliance by all users non-commercial and commercial users is key to make sure that research results can be used by commercial use in the end. So it has an impact on collaborations, public-private partnerships, projects that we also talk about today. So I just want to go through the relevant provisions of the EU regulation to finish. What applies to projects and research funding, where obligations may also be present for some of you who are involved in projects. So there is Article 7 of the EU regulation, which is about monitoring user compliance, and it basically says who has to make a due diligence declaration at what stage. So the first paragraph of this Article 7 says that all recipients of research funding, research which involves the utilization of genetic resources, they have to declare that they have exercised due diligence in accordance with the provision of the regulation which lays down the due diligence obligation. So anybody who is having research funding to do research on genetic resources has this obligation of making a due diligence declaration. There is a guidance document on the regulation, which basically gives some help to users to better understand their obligations under the EU regulation. The last version of this guidance document dates from 2020. I've put the link here in the slide. And it also clarifies on the personal scope of the regulation that it applies to all users. So it says very clearly the due diligence obligation applies to individuals, including researchers, and to organizations such as universities or other research organizations which utilize genetic resources or associated traditional knowledge. So it's very clearly clarified in the guidance document as well. There is also an implementing regulation to the EU regulation, which lays down certain elements of the regulation more in detail. And one of those elements is the due diligence declaration. So who and when has to do this due diligence declaration? And there is one article, Article 5, which really details how the due diligence declaration has to be done at the stage of research funding. So for research benefiting from funding. So normally it is the competent authority of the member state from which you received the research funding that has to ask you to make a due diligence declaration. And in case of EU-funded projects, it's the EU who will ask you to make a due diligence declaration. There is a template in this implementing regulation, but that has been implemented through an online tool, which is called Declare. And we can also come back to that later, through which due diligence declarations can be made. It also said in the regulation that the declaration has to be made after the first installment of the funding has been received and all the genetic resources have been obtained, but no later than the moment when the final project report is coming out or is published, or if there is no final report foreseen when the project ends. So there is a first moment and the last moment, which is basically defined in the regulation, which gives an interval when you can make your due diligence declaration, but no later than the end of the project, this declaration has to be made. And of course, national law, in case of member state funded projects, can also define a more precise date. And it's also said that at least one recipient of research funding has to make the declaration. So actually, in a project in a consortium where there are 20 consortium partners, not everybody will have to make a due diligence declaration individually, but you can agree that it's going to be the project coordinator who is going to make the due diligence declaration for or on behalf of all the consortium partners for the given project. It's also detailed further in the Commission guidance document, so it gives a little bit more idea on when and how and by whom these obligations have to be fulfilled. Of course, you can facilitate for yourself your compliance in a way. So you can put in place some practical approaches to help maybe consortia that you are working with to comply with the obligations that come from the EU regulation. And that is just an example that I've put in on the screen. It's what Euroseas has done for its own members, drafted its own sectoral recommendations for Euroseas members to help them, to help the companies to actually put in place a practical internal system on how to try to comply best with the obligations coming from the EU regulation. So setting up an internal scheme for compliance for yourself is really key. That will help you not only in compliance, but also in collaborating with authorities if you are checked on compliance.